Welcome to Hall and Estates and Succession Planning, a series of podcasts hosted by Ian Hall and Susanna Popvic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull & Hull in Toronto, here are Ian and Susanna.
Hi, and welcome to Hull on Estates and Succession Planning. You're listening to episode 181 on Tuesday, September 15. Hi, Jordan.
Hi, Paul.
Good to see you today. We're pinch hitting today for Ian and Susanna.
Who are you? Are
I'll
you
be
Ian?
Ian.
Okay, you okay? Wow, that shouldn't be so hard for me to be Susanna. Sorry, Susanna.
There are big shoes to fill.
They're high shoes to fill. Yes, yes.
Today we thought we'd speak a little bit about estate and succession planning where there's a disabled beneficiary.
Right.
And the considerations that have to be taken into account when you're dealing with with a beneficiary with special needs like that, and you also want to take into account the benefits that that beneficiary receives and how you can maximize those benefits while providing for bequest out of the estate.
Right. Yeah. It's more common than certainly than I would have thought coming into this area that about how many families have somebody who's either disabled or there's a chance that they're not going to be able to work and be disabled. So it's very common. I
did a paper on Ontario Disability Support Program that we'll touch on, and there's over 225,000 recipients in Ontario of those benefits. And when you're planning estates, I would imagine there's many more beneficiaries who aren't recipients of ODSP that you would want to provide for and consider as well.
For sure.
So it's a very common issue, and it may also be an issue that's becoming more and more prevalent as our population ages.
Yeah, for sure.
So maybe we can discuss briefly Ontario Disability Support Program as the background for the special provisions that you may want to put in place or put into your estate plan. In Ontario, there's a benefit called the Ontario Disability Support Program that provides for benefits for disabled individuals, and it provides for financial assistance. There's other benefits as well, but maybe even more important benefits such as drug benefits and medical and dental care as well, or I guess dental care is the bigger one.
Right.
In order to receive disability benefits, you need to meet their medical criteria as being disabled, but you also have to meet a very difficult, I was going to say low, but maybe it's a high threshold as far as income and assets that you can have while still receiving the benefits.
And that's a good point, because they test both your income and your assets, which is, I mean, you could have a very low income and have assets, and that would disqualify you. So that's what we try to avoid when you're trying to apply for ODSP.
That's right. So I think the assets are $100,000.
Well, the assets, you can put it in a trust, but the threshold for assets is $5,000. So it's a very low. Now there are some things excluded, like a matrimonial, like a home, tools for your, but
important exclusions, and those can be taken into account when estate planning. So you can make a bequest of assets that are excluded and not disqualify a person from ODSP.
Right, but the threshold is $5,000 is very low. So what you're trying to avoid when you're planning that is not to give them assets that are going to disqualify them. Put them over the $5,000 mark.
Right. So
on the asset test.
So you could provide assets that are excluded from the definitions that the plan has, or what other mechanism can you use to avoid giving a person assets that would disqualify them?
Well, the first thing there's both the asset. So let's look at it from the asset point of view. The problem that estate planners have is that giving somebody an interest in a trust is an asset. Right. So the right to get income from a trust is an asset in itself, regardless of the income. It's something of value that you could sell, right? I mean, if I have an interest in a trust that's going to pay me income over time, I could sell that to you and generate money, because that's going to come. That income is going to come. So that's one of the things that we can't do if we're going to leave a bequest to somebody, is we can't give them an interest in a trust that is going to provide them with a guaranteed source of income, because that in itself is an asset.
It's an asset that will disqualify them.
Right.
So you can get around that by creating a trust that's entirely or wholly discretionary.
Right. That's what we try to do. So what the law says now is that if somebody has an interest in a trust merely as a discretionary beneficiary, in other words, the trustee doesn't have to give them a dime if they don't want to. Right. So it's purely discretionary. Then the court doesn't consider that to be an asset. because there's nothing
There's
that
no right.
No right, exactly.
Immediate or otherwise.
Exactly.
To that asset.
So that gets you around the asset test. So if you give them an interest, a purely discretionary interest in an estate, then that doesn't count as an asset.
Okay. And I guess in exercising their discretion under that trust, the trustee has to be careful not to make any distributions that are going to put the recipient offside of their benefits.
Right, because then we get into the sort of the income test, right? Because so it doesn't qualify as an asset. Now we've got to worry about the amount of income that a recipient can receive in any one year, which is, let's use a $5,000 number. So a beneficiary can't, or a recipient can't receive more than $5,000 per year from a trust or from a job or from gifts or any of that, because if they do, then they're offside on the income side. So now we have a trust in which they're not entitled to any specific amount. The trustee has discretion. They're going to try not to give more than $5,000 a year from that trust, or else they will disqualify them.
Right. Benefits.
Yeah. So they have to keep their eye on the ball and make sure that, now there are exceptions to that, right? That $5,000 is just pure gifts or income. But there are certain things you can buy for a disabled person, right?
Right, and that's an important consideration. I think there's a list of things that won't count as income or assets to the recipient.
Right, I think they're referred to as disability-related expenses. And so you can spend as much as you want on disability-related expenses and give the disabled person as much of those as they want without worrying about the amount.
Right.
It's just the extra income that they can't receive more than that, say, $5,000.
Another important exception that we see people trying to take advantage of often is a residence. You can own a principal residence in even a cottage property and not be offside on the asset side of it. The difficulty is, though, how do you carry that?
Right. I mean, $5,000 doesn't go very far.
It doesn't pay very many taxes at all.
You know, I think ODSP now pays somewhere between $700 and $900 a month. That, you know, you can scrape together that plus the $5,000 that you can get in any 12-month period. It's not a calendar year, so there's all kinds of things you got to be worried about when you're dealing with that. But yeah, I mean, it doesn't go very far for sure.
So from the estate planning side of things, the trust that we're talking about, the discretionary trust or the Hansen Trust, is an important tool to keep in mind.
Sure.
I mentioned the $100,000 figure. I think I was referring to or thinking about the disability trust, or the trust that can be established if there is no Hansen Trust in place, and the ODSP recipient can have the can receive up to $100,000 from an estate or insurance proceeds and shelter that in a trust.
Right. So that's a sort of it's an exempt asset. So you can have an interest in a trust as long as that trust is no more than $100,000.
Right.
And so what we see sometimes is a parent hasn't planned properly. They leave their disabled child $100,000. That child, instead of if they received it all, it would be their asset. $100,000 puts them way offside. So what they do is they take that $100,000 and they can shelter it in a trust. And then they get the income from that, and as long as the income from that is less than $5,000, then they're okay.
And they're okay on the asset side and the income side.
But that $100,000 is I mean, it's sizable, but it's not. If you leave them $1 million, you can only shelter $100,000. They're going to be offside.
They're going to be disqualified.
Yeah.
So there's no point there.
Yeah. So it's a tricky business.
Mm-hmm. Well, it was good discussing those issues with you.
Well, Ian, you're looking dapper today.
Well, thank you very much for watching and for listening. If you want to leave a comment, please contact our website, where you can get links for leaving comments.
Good. I haven't got any of those yet, so maybe after this one.
You might get a few, Dale.
Good. Excellent. Thanks, Paul.
Thank you.
You have been listening to Hall and Estates and Succession Planning by Ian Hall and Susanna Popvic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hall podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.